All right then, the fourth and so far the final day of the Assange hearing. It's been recessed until May 18th, so we'll go through the fourth day and see if we can figure out any kind of sensibility coming from the prosecution or that Dalek of a judge that's over this case. So Murray wants us to try an experiment. Try asking this question out loud in a tone of intellectual interest and engagement. Are you suggesting that the two have the same effect? Now try asking this question out loud in a tone of hostility and incredulity bordering on sarcasm. Are you suggesting the two have the same effect? Firstly, congratulations on your acting skills. You take direction very well. Why, thank you. Hostility and incredulity bordering on sarcasm is a particular skill of mine. Secondly, is it not fascinating how precisely the same words can convey the opposite meaning dependent on modulation of stress, pitch, and volume? Yep, and this is a point I have been making for years, trying to point out how important this is to people. You know, especially when you're trying to make it show up in text, and so you use capital letters for emphasis, and they go, you used caps, that means you're bad for some reason that I'm not going to explain. No, it just means they don't like being called out. You know, if you use capitalization to stress for clarity, then they can't take your words out of context. But what he's talking about here is something Mark Twain pointed out. You can give someone a written transcript of a speech, but you cannot give someone a written transcript of a talk, because a speech is written out and basically read by the person who's giving the speech. A talk is just someone talking, and he has stresses and all sorts of things that give context to what's being said. And so Murray says, James Lewis for the prosecution spoke for about an hour, and Edward Fitzgerald replied for the defense for about the same amount of time. During Lewis's presentation, he was interrupted by Judge Barrister precisely once. During Fitzgerald's reply, Barrister injected 17 times. In the transcript, those interruptions would not look unreasonable. Could you clarify that for me, Mr. Fitzgerald? So how do you cope with Mr. Lewis's point that... But surely that's a circular argument. But it's not incorporated, is it? All these and the other dozen interruptions were designed to appear to show the judge attempting to clarify the defense's argument in a spirit of intellectual testing. But if you heard the tone of Barrister's voice, saw her body language and facial expressions, it was anything but. The false picture a transcript might give is exacerbated by the courtly Fitzgerald's continually replying to each obvious harassment with, "Thank you, madam, that is very helpful," which, again, if you were there, plainly meant the opposite. "Oh, thank you, madam, that's very helpful." Yep, see, it's all about the tone. But what a transcript will helpfully nevertheless show was the bully pulpit of Barrister's tactic in interrupting Fitzgerald again and again and again, belittling his points, and very deliberately indeed preventing him from getting into the flow of his argument. The contrast in every way with her treatment of Lewis could not be more pronounced. Okay, so let's get back to these bewildering arguments we left before at the end of day 3. And Lewis is saying that Parliament had not included a bar on extradition for political offenses in the 2003 Act. It could not therefore be reintroduced into law by treaty. To introduce a political offences bar by the back door would be to subvert the intention of Parliament. Lewis also argued that these were not political offences. The definition of a political offence in the UK was limited to behaviour intended to overturn or change a government or induce it to change its policy. And that wasn't what Assange was trying to do. Why? Furthermore, the aim must be to change government or policy in the short term, not the indeterminate future. Yeah, again, seems to meet what Assange was trying to do to me. He then went on to say that a political offence could only be applied to offences that occurred within the territory, so Assange would have to have committed them in the USA in order to be guilty of them, and he didn't, and I don't know. So again, Lewis's claim is that the conduct of Julian Assange cannot possibly be classified as a political offense. It is impossible to place Julian Assange in the position of a political refugee. The activity in which WikiLeaks was engaged was not in its proper meaning political opposition to the U.S. administration or an attempt to overthrow that administration. Therefore, the offense was not political. Fitzgerald replied that the 2003 Extradition Act was an enabling act under which treaties could operate. Parliament had been concerned to remove any threat of abuse of the political offense bar to cover terrorist acts of violence against innocent civilians. But there remained a clear protection, accepted worldwide, for peaceful political dissent. This was reflected in the extradition treaty on the basis of which the court was acting. Barrister interrupted that the UK-US extradition treaty was not incorporated into English law. Fitzgerald replied that the entire extradition request is on the basis of the treaty. It is an abusive process for the authorities to rely on the treaty for the application, but then to claim that its provisions do not apply. On the face of it, it is a very bizarre argument that a treaty which gives rise to the extradition on which the extradition is founded can be disregarded in its provisions. It is, on the face of it, absurd. And then he gave a bunch of examples of when English courts are construing treaties, and went on that the defense did not accept that treason, espionage, and sedition were not regarded as political offenses in England. But even if one did accept Lewis's too narrow definition of political offense, Assange's behavior still met the test. What on earth could be the motive of publishing evidence of government war crimes and corruption other than to change the policy of the government? Indeed, the evidence would prove that WikiLeaks had effectively changed the policy of the U.S. government, particularly on Iraq. Barrister interjected that to expose government wrongdoing was not the same thing as to try to change government policy. Fitzgerald asked her, finally in some exasperation after umpteen interruptions, what other point could there be in exposing government wrongdoing other than to induce a change in government policy? So Murray gives commentary where he tries to be as neutral as possible. If you could fairly state that Lewis's argument was much more logical, rational, and intuitive than Fitzgerald's, you could understand why Lewis did not need an interruption, while Fitzgerald had to be continually interrupted for clarification. But it was in fact Lewis who was making out the case that the provisions of the very treaty under which the extradition is being made do not in fact apply. Barrister's comparative harassment of Fitzgerald when he had the prosecution on the ropes was straight out of the Stalin show trial playbook. I thought Lewis's point that these could not be political offenses because Julian Assange was not in the USA when he committed them was breathtakingly dishonest. The USA claims universal jurisdiction. Assange is being charged with crimes of publishing committed while he was outside the USA. The USA claims the right to charge anyone of any nationality anywhere in the world who harms U.S. interests. They also, in addition here, claim that as the materials could be seen on the internet in the USA, there was an offense in the USA. Oh, we've seen that a lot, haven't we? Europe has been doing that to try and claim jurisdiction to regulate the web all over the world because, oh well, people in Europe can see the website. Article 11, Article 13, and all of that stuff. At the same time, to claim this could not be a political offense as the crime was committed outside the USA is, as Edward Fitzgerald might say, on the face of it absurd, which curiously Barrister did not pick up on. And he goes on to point out that this idea of the treaty not having any standing in English law is something that has come from a few other places as well. It's not a new idea, but there's a whole bunch of judgments that go against it as well, and those going against it are more recent. And he says, the difficulty for Lewis and for Barrister is that this case is not analogous to me buying a Mars bar and then going to court because an international treaty on Mars bars says mine is too small. Rather, the 2003 Extradition Act is an enabling act on which extradition treaties then depend. You can't thus extradite under the 2003 Act without the treaty. So the Extradition Treaty of 2007, in a very real sense, becomes an executive instrument legally required to authorize the extradition. For the executing authorities to breach the terms of the necessary executive instrument under which they are acting simply has to be abuse of process. The extradition treaty is a necessary precondition of the extradition, whereas a Mars bar treaty is not a necessary precondition to buying the Mars bar. That is as plain as I can put it. I do hope that is comprehensible. We get it, and it lets us see exactly what this court is up to. It is, of course, difficult for Lewis that on the same day the Court of Appeal was ruling against the construction of the Heathrow third runway, partly because of its incompatibility with the Paris Agreement of 2016, despite the latter not being fully incorporated into English law by the Climate Change Act of 2008. So, booyah! Now, when he's talking about his personal experience, realize that for decades, this guy has been a university rector, a diplomat, the ambassador to Uzbekistan, all sorts of things. This is a guy who knows what he's talking about. And he says, I need to explain I have myself negotiated and overseen the entry into force of treaties within the FCO. The last one in which I personally tied the ribbon and applied the sealing wax, literally, was the Anglo-Belgian Continental Shelf Treaty of 1991, but I was involved in negotiating others, and the system I am going to describe was still in place when I left the FCO as an ambassador in 2005, and I believe is unchanged today. And remember, the Extradition Act was 2003, and the US-UK Extradition Treaty ratified 2007, so my knowledge is not outdated. So he goes into a two-stage process the treaties have to go through. They're signed to show that the government agrees to the treaty, and then after a delay, they're ratified. That delay allows for the legislation and other relevant agencies to implement the treaty. And the ratification stage can only take place after the required legislative action. And it's also vetted to make sure that it can be fully implemented within the jurisdiction. If not, then they have to make a lot of amendments to it. And in the UK, those amendments can be made by an Act of Parliament or by using powers conferred on the Secretary of State. If there already is an Act of Parliament that allows that treaty to be implemented, then Parliament doesn't need to pass any additional legislation. The Secretary of State is empowered to do that. So treaties and international agreements are not all individually incorporated one by one into English or Scottish law by Parliament. And he says, only when all hurdles have been cleared, including legislation and parliamentary officials, Treasury, Cabinet Office, Home Office, and FCO all certify that the treaty is capable of having effect in the UK, will the FCO legal advisors give the go-ahead for the treaty to be ratified. You absolutely cannot ratify the treaty before FCO legal advisors have given this clearance. This is a serious process. That is why the US-UK Extradition Treaty was signed in 2003 and ratified in 2007. That is not an abnormal delay. So I know for certain that all the relevant British government legal departments must have agreed that Article 4.1 of the UK-US Extradition Treaty was capable of being given effect under the 2003 Extradition Act. That certification has to have happened, or the treaty could never have been ratified. It follows of necessity that the UK government, in seeking to argue now that Article 4.1 is incompatible with the 2003 Act, is knowingly lying. There could not be a more gross abuse of process. So that's where he's left off, and that's where the hearing is left off for now. He wants to make another post further on yesterday's row in court over releasing Julian from the anti-terrorist armored dock. And again, I'd really be interested in hearing more about that. But otherwise, that would do it. The case resumes May 18th, where Assange's lawyers will be allowed to call witnesses. Here's hoping it goes better for him, though the obvious bias of the drumhead Judge Dalek sadly makes that unlikely. Until next time, stay strong and be free.